And beep boop. All right, so we did not complete the lecture on chapter 15, lesson 6, which was on a right to privacy. And this might seem like a odd place to include the right to bear arms. Usually we think about the right to privacy as being a Ninth Amendment thing and an extension of that Third Amendment of no quartering of soldiers, an extension of the Fourth Amendment, search warrants, an extension of the Fifth Amendment, right to not incriminate yourself and to have private property. We generally view those and the Ninth Amendment as creating the right to privacy. The Second Amendment seems like an odd duck to include there, but I think our textbook makes a good case for it based off of the 2008 landmark case of DC versus Heller. Prior to 2008, there was not a lot of Supreme Court case law dealing with the Second Amendment. The court was generally reticent to take a lot of Second Amendment cases or clarify what exactly the Second Amendment meant, at least in terms of private individual gun ownership. And then the DC versus Heller case really breaks a dam there and gives us several guidelines on what the Second Amendment means and what the status is of private individual gun ownership in the United States. The reason why DC versus Heller will always be a part of textbooks is that first part of the ruling there, that the Second Amendment does apply to private gun ownership, not just to what the Second Amendment literally says, which is a well-regulated militia. The Second Amendment does, to some extent, protect the individual's right to own a gun, not just the militia's right to remain armed. But, and then here's why this fits in with chapter 15, lesson 6, and the other items there, that's telling an individual how they are to keep a gun in their home. In the case of the DC policy, telling them that the gun must be disassembled, telling them that the gun must be trigger locked, is an inherent violation of privacy rights within the own home. That you can prevent gun crime within the home, but you can't prevent somebody from storing the gun as they see fit through legal statute. That has been interpreted and reinterpreted, and there have been lower court rulings and localized rulings on the Second Amendment since 2008, and courts tend to be more willing to intervene in gun law in the modern day, but that is the basis of most national law. The other thing that makes DC versus Heller an essential case is the first part of the name, DC. Laws for Washington, D.C. are made by the local government in Washington, D.C., but that is a government that is accountable directly to the U.S. Congress. So really we are dealing with national level laws there, which means that obviously the Second Amendment applies, it's part of the national government, and it is part of the Constitution. A case that is not as well covered by our textbook, and a case that is equally important then, is the 2 years later in the 2010 case of McDonald versus Chicago, the Supreme Court ruled that not only does the Second Amendment protect individual gun ownership, but the Second Amendment applies to state governments as well, and just in the way that the national government cannot ban legal gun ownership, the state governments cannot ban legal gun ownership. Now, state governments can regulate, and the national government can regulate gun ownership. They can set laws on what types of weapons are permissible. They can create gun-free zones. They can create requirements for where weapons are allowed to be carried, how weapons are allowed to be displayed, when you are allowed to conceal, what are or are not allowed to concealed carry a weapon. They can create registration requirements. They can create background check requirements. All of those types of regulations can be made so long as those regulations are both rational and viewed by the court system as being issued on a rational basis. No guns if you're under 12. But also then, as long as those are not viewed to directly contradict the Second Amendment with this sort of basic promise of gun ownership in general will not be restricted. So it cannot have the effect of outright outlawing gun ownership, as was the attempt in both the DC law and the Chicago law of trying to create these pinchy little loopholes of, oh, well, you can't register a gun and your gun has to be registered, so ha ha, gotcha. Or the, well, it has to have this impossible restriction on it. Those types of restrictions are shot down by the courts when attempted to be put into place. And gun freedoms that also pertain to concealed carry people too. Leah, fantastic question, and the answer I will give there is a check your listings and check your local policies and permits. Generally speaking, somebody who has a concealed carry permit, such as somebody who is working with law enforcement, can be exempted from those types of laws. Yes. Not always, and that's the kind of thing that you would go over in a concealed carry class and that you would learn if getting trained in concealed carry. Generally speaking, though, the idea of concealed carry is that those individuals are licensed and allowed to hold in areas where otherwise you might not be able to. So the government can create laws and can create restrictions, but they cannot use these restrictions to effectively attempt to outlaw individual gun ownership. I want to talk about a couple other places where right to privacy comes up that our textbook does not cover. Oh, you got to be on it and then click it to. Although to some extent, well, I just want to throw back to and acknowledge these. Back in the day when we had schools, you may remember that we did the newspaper theater sketches. For many of you, yours was inherently a right to privacy case. The first one that comes to my mind is the Kylo case and the use of thermal scanners to search one's house. Well, that is inherently a right to privacy case. Desjardins versus Florida, just the dog walking by and being curious is a right to privacy case. And there are a lot of places where we do see the right to privacy come up in criminal defense law. A couple other examples of the right to privacy. Another one that used to be mentioned much more by textbooks, but seems to be eliminated in favor of same-sex marriage laws, is the court case that protects same-sex relations. In 2003, well, I suppose a better case to throw back to would be in 1986 in Colorado. Colorado had a state law that prohibited homosexual sexual activity, even if occurring between consenting adults and occurring within the privacy of the household. In 2003, the Supreme Court overturned a similar Texas statute and nationally has overturned similar statutes, saying that what one does within the privacy of their own home is generally understood to be both private and protected, and that the court cannot create a law, or I'm sorry, not the court, the state governments cannot create laws that govern that type of private activity, secret handshakes and the like. One that we looked at when we were updating our textbook was Carpenter versus the United States, and some of you all responded to short answer questions about Carpenter versus the United States. Carpenter is really what I feel is going to be the next wave of privacy cases, which is to what extent is my digital footprint private? To what extent does my existence online have the same protection as my existence within the home? In Carpenter, we started to get the idea of, nope, if you are obtaining evidence against somebody, you still need a warrant, if it's evidence that would not be readily visible to the police, then they still need a warrant. In Carpenter, this was applied to cell phone location. The police cannot simply look up with the cell phone company where it was that one cell phone was and use that as evidence against them. They must first get a warrant, and then that can be perfectly admissible. But they cannot do that without first justifying to a court that they have reasonable suspicion, which would be the grounds that would grant them that warrant. We'll wrap up our school year with criminal defense law and the rights of the criminally accused in chapter 16, which will be a nice area for us. I think that there are a lot of fun questions that come up there. But that is the end of our chapter 15 material. For the chapter 15 quiz coming up, you still need to be on the right screen if you're going to click the right arrow to make it go forward. You know, it's like we don't learn. The quiz. I still like having some objective portion to the quiz, so this one will be half objective, half written. It will be like the reading checks that we have been taking at the beginning of class. It will be a Google form. I will give you a password at the beginning of class to get into the Google form to make sure no one is going in prematurely and taking hours upon hours. It will be 10 multiple choice questions. These will be based off of both the reading and the lecture material. I'm going to allow this to be open note and open book simply because I don't see any other reasonable way that it can be run. You do have the slides from this presentation on campus, and you do have your textbook. So the questions I will ask you will be kind of second level questions. It will expect you not just to have looked up a definition, but to show that you understand the material and how it was applied there. And then I'll ask 3 free response questions. You choose one and respond in a paragraph. That'll be 10 points. Each question will be worth 1 point, 20-point quiz overall. That will be our game that we play next class. For you all, it's Wednesday. For the people who watch this video in the future, it might be Thursday or it might be Wednesday, depending upon their flavor of class. I'm going to stop the recording and I'm going to stop presenting, and then I will take questions. Bye recording, bye internet.